How's it going? This is attorney Sherrod Seward, and today I'm speaking on the question I get asked a lot, which is how I ended up blacklisted a bit by the Department of Homeland Security and USCIS, which is actually a story that spans a couple of years now, but it's centered on one thing, really trying to advocate for the exclusivity and the full work authorization rights of athletes, especially those that compete individually in sports such as track, combat sports, poker playing. But also now this goes on to other industries, even if you are a computer scientist and you want to have your autonomy to be able to work for multiple employers on one visa. And what's the big deal? Well, imagine that you have one employer that's in charge of your whole entire existence in the country. That means that they tell you where you work, how much you can work for, and if you decide not to, they can pull your visa. Well, that's the state of a lot of people that are in the country on proper work authorization, especially in sports. And my sport that I specialized in was combat sports, boxing, and mixed martial arts, where most often the promoter would hold the visa, which allows them to exert a lot of pressure on the athlete to let them know when they can fight. Should they fight if they're on an industry on an injury? Is there a particular opponent that they want them to face before they're ready, or do they want to deny them a championship? Things of that nature. That's all tied to the visa, and usually they're the ones that purchase it. Well, the first time that I was requested to go get a visa is for somebody that didn't have a professional career yet. They had just come off the Olympics, won a bronze medal, and they were a female fighter, to which there's not necessarily a lot of money in, especially if you can't negotiate where you're going to go. And there's also not a lot of promoters willing to stick their necks out and spend the thousands of dollars necessary to get the P1 or the O1 visa that's there. So a lot of the business that I did before I had relationships with major promoters were with agents. A lot of times with small agents that might only have one or three fighters on their roster, especially those that are of the caliber that could get a professional bout. Now, mind you, a lot of people don't know this, but if you're in the UFC, I think now you get 15,000 to show and 15,000 to win on your first fight. But a lot of these other promoters, you might be just getting a couple $100 to come and show up, and maybe nothing to win. And it's just a very cheap and hard sport to do when you're first starting out. And that's including other sports like track, where you might necessarily get any prize money or sponsorship, but you're trying to figure it out. But the thing that I did was I used to place the visas with the management or even a third party, and then use the itinerary of the promoters to show where and when they might be fighting. For example, if I have a boxer, I would use the itinerary of Top Rank Boxing, Matchroom Boxing, Oscar De La Hoya's, by saying like, hey, these are the schedule that they have going up this year, and it'll repeat likely in the next 3 years. And their manager is going to be navigating and directing them where and which one of these promoters they should get to and be in. Now, this was great for the whole industry. It was fine. The managers were loving it, and the promoters were loving it because they didn't have to pay for visas to have international fighters that had great rankings always available for their fights that they didn't have to invest in. And then what started happening is USCIS started pushing back and asking for the names, dates, and locations and venues for fighters that they would be competing in over 3 years, which of course is impossible, and it's an asinine thing to ask because there's no way for them to know that. But also looking back, it can't be legal to ask that because no sport really knows that. Even today, which is in April, we don't have the NFL schedule for when exactly and where they're going to be competing the same year, lesser known 3 years from now. And you can say that for any type of sport that's out there. I can't think of a sport where you would know that they have the exact locations and dates that you'll be competing every time over the next 3 years. So we started suing them. We started pushing back. We started doing press, and they got upset. So after doing maybe about 3 lawsuits with them, there was a particular lawsuit that we did in the one of the districts in Massachusetts, because that's where the manager of this particular fighter was. And let's talk about what USCIS did. They're so smart. So I explained to them that I had a promoter that I had a relationship with that does fights on UFC Fight Pass. UFC Fight Pass is a broadcast application that you get on your iPhone, and it still exists today, where they stream a lot of fights from other promoters and all types of sports. These idiots go on and send me a request for evidence or a denial. One of them saying, "Hey, we looked at the UFC schedule and we didn't see the person on there." The big problem is that is a completely different sport than boxing. That is mixed martial arts. So I gave them some choice words where I said that. And when I sued, I put that information in there that was in there. The other thing that was going on at the time while this lawsuit was being prepared is it got so bad that I went to all my connects around the world, because I know managers, promoters from around the world. And I said, hey, we need to do a petition where we help establish in general the expectations of immigration in combat sports. To be specific, what we wanted to show them is that promoters like it when their itineraries are used by fighters getting visas, so that way it can be contemplated that they can, fight on those promotions. And at those times, I was actually the general counsel for immigration purposes for several large promoters, and I had personal relationships with a lot of matchmakers and things of that nature from around the world. So I get this package together. It's about 80 pages that says the general way of doing things in combat sports. And all these letters are pretty much the same. And they're from like 50 different people. What USCIS does to try to get the plaintiff that I had to dismiss the case is they go to everyone that signed that letter and they ask them, do you know this particular fighter and this promoter here? Knowing damn well that the evidence was presented as an explanation in general of how the industry works. So of course, one of those finds that to a competitor. And by competitor, I mean maybe the second biggest promoter in the world gets a message from USCIS about the third biggest promotion in the world, asking about a particular fight for a competitor. So of course they get pissed, and then they get mad at the matchmaker, and then the matchmaker, 1 or 2 out of 80 people that they went through, tried to act like they didn't authorize the letter to be used for the purpose, which wasn't true. But that is how USCIS was able to do tactics like that and other tactics they do underhanded to exert intimidation and other things to, 1, stop cases from being litigated, and 2, to stop personally me from filing Freedom of Information Act requests on behalf of fighters and on behalf of the law firm, where we look for government transparency to see who is making the decisions and how they are coming up with it. But that's how we got here on this blacklist, and that's where we're going to stay, but we're not going to be deterred. We're going to still continue with our litigation because it's illegal to stop people from filing for a request, and it's against the American values of government transparency, which we do not take lightly, and we should not let them get away with it. But that is the long story short, and I will get into more details of this because I think it's important for people to know how the government can use tactics to dissuade you from using the rights and tools available to you to defend yourself and also to defend transparency in general. And then second, there's going to be a lot of nuances that people in practice, whether it be law or other high-level professional services, can use to navigate these regulatory bodies and provide optimal service to their clients. With that, I look forward to diving more into this and providing more content and relatable stories of my journey from sports immigration attorney to blacklisted by Department of Homeland Security. Have a great day.